So good morning, and thank you for everybody to join us today on our first seminar on the 2023. We are happy to be having all the people coming again together on the in-person meeting, which is showing that the human being going back to what they're supposed to be, not to be on behind the screens. But also I'll welcome the people who is online with us on this session. Thanks for the panelists with us also today. All of them is well-known and prominent speakers. I won't introduce them because they are much known than me, so I won't talk about them, but they will talk about themselves later on. Today we are and this seminar is we'll have a different points to talk about it. I think we are in UAE. It's proud to say that we are welcoming a lots of people from different parts of the world to have them in Dubai and in UAE also. And we in Horizon always we adopt the same policies, and the way our leaders actually they make it for us is this country is for everybody. We are always welcoming the people regardless from which part of the world they are. That's why this areas of the world is actually bringing lots of different practitioners together in all sectors, and that is the beauty of our region here. That's what we will also talk about it today on with the panelists here. They will talk about the all legal system is available in UAE, which is also a unique system where we have a civil and common law in the very small part of the region. So that is a beauty. You have everything is together, people coming together here. We welcome all the profession from all the world. I'll be happy, of course, with my panelist people in the first session to talk about the UAE system, and hopefully will be our info and speech will be very useful for you guys, and we will be welcoming after our presentation and the speech of each of the panelists to have questions from all of you guys. So let's start it, and for everybody, most welcome to be with us here in Horizon. Thank you.
Good morning, everyone. You already met Mr. Ali. I could spend a long time speaking about the achievements of Mr. Ali, but I will be brief introducing his brother. Mr. Ali is one of the leading advocates in UAE and has over 25 years of experience before all courts and arbitration tribunals in the country. Mr. Ali is regularly appointed as arbitrator under the rules of major institutions such as the Dubai International Arbitration Center, the Islamic Center for Reconciliation and Arbitration, and International Chamber of Commerce, and also acts as a legal expert in arbitration and litigation proceedings around the world. Mr. Larry will provide us with an overview of dispute resolution before UAE courts and arbitral tribunals, and in particular will address the court system and the UAE Federal Arbitration Act. Mr. Ali, the floor is yours.
Thank you, Rodrigo. So I think the speech here is very rich, so I'll try to make it the point which I will address it as short as I can, because talking about this subject may take us a lots of other, not one 15 minutes. They give it to me 15 minutes, it seems. So 15 minutes won't be enough, but we'll try to make it. So for those who doesn't know the system of UAE, it's a federation, have 7 Emirates, and in this federation we have a unique two things actually of a system. We have a federal system, and we have the constitution give also all the Emirates the right to have their own judicial system. So that is what some people they will say, how will be federal, and then each Emirates can have their own judicial courts. That is a part of our constitution. So the constitution allow each Emirates has to have their own court system. In beginning of United Arab Emirates, there was most of the Emirates, which was Ras Al Khaimah, Sharjah, Dubai, even Abu Dhabi, was very active. So they used to have what we called it a local law for criminal, for a civil, just for the Emirates of each Emirates. So then there was a federal rules and regulation has been issued by the federal government. Then lots of Emirates, they decided to adopt it. So we have the choices is there, but because of it is a small country, it's always used to be more useful to be using the federal law, which is making the whole country working under one umbrella of the law. So during the years after the 80s, then each Emirates, they decided to adopt the federal law in all criminal, civil, transaction, commercial transaction, company laws, and try not to and somehow get rid of their local law. So each Emirates, there is a federal court, except the Emirates, which they decided to have their own local, we call it local courts. Abu Dhabi has, because they are a capital, they have a dual, they have a federal and they have a local, which is Abu Dhabi courts, judicial courts. Dubai, they have only a local one. Ras Al Khaimah, they have a local one. Rest of the Emirates, they have a federal courts. Laws, most of the laws has been applied now today. It's across the board is a federal law, except on certain Emirates in the property law. They decided they haven't agreed to have one property law for all the Emirates, and there is now you find a property law is different from each Emirate. Some Emirates they have it, some Emirates they don't still have it, but that is the beauty. It depends on how progress you are. Dubai fastest progress, so they decided to have the property law available. So the law of UAE also is in the beginning of the United Arab Emirates was always based on Sharia law, and it was the main in the beginning was the main source of the law. Then during the progress, then it become one of the sources. Today it is more modern, but still there is a spirit of the Sharia law is there, but it is much less than all time. So it's more about how we make it the rules and regulation of UAE more international than just stick to the Sharia, because that's because we are an open country and we have multi-nationalities, multi-religious. So then we need to adopt everybody, and that's why the government said it will be one of the sources, but it won't be the only sources. So all rules and regulations it's keep developed. So they developed lots of rules as of till 2022 was major changes are still happening on the major law, new laws coming up, which was not existing, improving a lots of old laws available to make it more modern. So that's make things it's more acceptable for a business purpose. So business purpose, family, also who are coming from a different part of the world. Now we have Sharia for a Muslim rules, and we have non-Muslim rules, which is also a civil marriage there and others, which is making the reason. And if you look at it, it's always the government was looking to keep this area is a host of everybody, their profession people, their families. They need to feel everybody that they are sitting on their home country. This is the beauty. It's mix of a lots of rules and regulation, which is suit majority of the people living in UAE. So if we talk about the court levels as the system here, they have 3 levels of the court: first, an appeal, and high court. Federal court, they call it high federal court, but Dubai, they call it cassation. Abu Dhabi, they have also their own high courts also. So that is also another unique situation, because you have 3 high courts in a small areas of like a UAE. So that is now the challenge of having contradicting principle, let's say principle coming from the high courts. That's created issues in the beginning, but also UAE, because they are a very dynamic government, they also put now the committee which look after all the principle coming from all 3 high courts, and then merge it and make it one principle across the UAE. So the decision from the courts in UAE, whether it is a federal or it's a local, won't contradict each other's. This is also, it's an initiative by UAE just to make the legal judicial system completed, because you don't need to have lawyers fighting over a different principle on the same matters. So that will be difficult even to persuade the arbitrators, if you are in arbitration, which judgment which is more persuasive than the others. So now this development is there. Talking about the developments in 2021, there was about 50 law has been changed, and in 22, those 50 has been amended. So people, they said that's a nice thing. We haven't finished 1 year. Yes, it is tough for the practitioner, but I think so that there is a good part if you look at it from positive part. That's the government and everybody of practice in the legal practice. They know that the changing of the rules is one of the most difficult part on any country, because there is a lots of debates. There is a lots of parties, they won't like the changes. So changing in 1 year the same numbers of the law, it is not a weakness, and at least my point of view, it is a positive, because then you have an engine behind that law to change it and make it much better, because you can't, and any law when you issue it, you always will have an issues on those laws. How you can manage it, it is only by the way of make it quick change. Otherwise, you need to spend the years. Then there is a lots of judgments will come, which won't be pleasant for a lots of people on UAE or the companies. Then it will create more problem. So it's better to make it a quick change, which they did it, and they make it more modern. They merge a lots of cabinet decision to make it on, instead of a different cabinet decision to make it on the law. So that's make it the rules and regulation, in addition to all the new law and regulation has came on, which is really make it lots of shrinking the difference between the system in UAE and the international system. Talking about the arbitration also, I'm a little bit worried to talk about it because Philip is here. He was part of that law, but both of us, we was actually adding value to this law because we are a practitioner. So we put a lots of comments on the law. In 2018, the law of first arbitration law had been come up of UAE, which was great, because the debate about the having UAE lots of disputes on arbitration and have a zero law on dealing with. Yeah, they give me a time. I know this. Okay. Thank you, Rodrigo. I'll talk to you afterwards. Okay. So That law came actually, it's adopting a central system. A lots of positive. It's not a perfect law. I have to admit it as a practitioner, but it is really a big jump, because from a few articles on civil procedure law to a full law, it's amazing. It's helping a lot. It's covered a lot of arguments, was debates on the courts about the decision about the jurisdiction of tribunal for their own jurisdiction. Now in this law, it's allowed to the tribunal to decide on their jurisdiction. Then also there is confidentiality. They adopted the confidentiality. They try to limit and make it quick. So that's a reason they said 6 months, and then maybe the party they agree, but they are showing that the laws was trying to make it speedy. Also, there is a good things about any mistakes on signatures on forms. Then the tribunals can change it, so it will not lead to the nullifications. The challenge, they limited a lot of the challenge, which is was very good, because it was very open. Now it's limited to a certain part of challenge, which is make it easy, and that's support to the decision will come from the tribunals award, so it's less. So after that law, actually in a practice, less nullification judgment came against those awards. So most majority of the award has been ratified by the court. The process of ratification has become super quick. On 60 days, everything is done. And that is in the old time, usually you would take a year to finish it. Now it's no more than. The execution, it is quick. So these are, there is so many things we need to talk about arbitration, but because I have that 5 minutes I think is finished, but I'll take 1 more minutes. Okay. So we have also jumping from the rules to the companies. We have a system of mainland versus free zone. It used to be a free zone having a lots of advantage on the mainland, because they have a ownership 100% there for expatriate. In the mainland was not available. Now it's available. So the shrink, it has been shrinking a lot between mainland and the free zone. Ownership has become for an expatriate 100% without needing any Emiratis partners in major part of the activities, which is also welcome, except certain activities, which is mainly it is on the main sector, which is energies and defense. That is required to have an Emiratis for a obvious reason. I think then last point is UAE also has a civil law courts, and we have a DIFC, ADGM, common law courts. That was also one of the initiative of UAE government. It is a beauty, nice, complement the system. There is some conflict happen. Government again come and try to resolve it by having a committee. I don't want to talk about the DIFC because my other speakers, they will have their own views. So I am, as a practitioner, I'm practicing in both. I think it's nice. It is refreshing the brain. So then you challenge between two, and the lawyers, they try to find a way to find a gap between them. So I hope I was not taking much of your time. Thanks a lot. And please go to Philip after that.
Thank you much, Mr. Ali. We will narrow from this big picture of UAE, we'll narrow the focus to the DFC and ADGM, which are what we call offshore jurisdictions. And Philip Unvar will guide us through that offshore jurisdiction. Philip is an English barrister with over 25 years of experience in international arbitration. He's acted as arbitrator in ad hoc, ICC, DIAC, and LCA arbitrations. and has appeared as counsel before all levels of the English and DFC courts. Philip, the floor is yours.
Thank you very much indeed. Good morning, everyone. I'm rather jealous of you if you are a UAE newbie, because the topic of this session is choosing a dispute resolution forum for UAE newbies. There's a real danger that legal practice for you in the UAE might be rather boring, because so much has happened over the last 15 years that, as Ali was indicating with respect to arbitration in particular, there is actually an awful lot more certainty now for us litigators than there ever was. Certainly when I arrived in the UAE in 2005, it seemed to me that if you came to the UAE then, you were probably going to be a newbie for the next 10 years. Whereas with everything that's available to you online and at presentations like this, you really have no excuse if you're not an expert by the end of the year. My topic is the offshore litigation landscape. And so we are going to be touching on the DIFC and on the ADGM. The first thing to recognize is that the Dubai International Financial Center courts exist within a financial free zone, which was established in approximately 2004. And the reason the Dubai government wanted to establish an economic free zone of that nature was to encourage foreign investment, of course, and it was correctly identified. It was correctly noted that investment into a country like this from Europe and elsewhere was sometimes problematic simply because of the language, and also because the legal jurisdiction was a civil law jurisdiction rather than a common law jurisdiction. So it was thought that it would be attractive to foreign investors to establish economic free zones that could operate under their own civil and commercial laws. And so that's why when you're in the DIFC courts, you will find that in more often than not, you're going to be applying DIFC law to your disputes rather than any other. The courts, as I said, were established at the outset. They were established in 2004. They are common law courts, and that means that they are modeled essentially on the English High Court, and indeed the rules of the court are pretty much, in their origin at least, word for word those of the English civil procedure rules. The court has developed at a phenomenal pace, but there is competition now in the ADGM. When I came here in 2005, the court was in the process of being established, but we didn't have any rules and we didn't have any courtrooms, and we had two judges. We had Sir Anthony Evans as the Chief Justice from England and Michael Wang, the Deputy Chief Justice from Singapore. The court ultimately adopted its rules, but those of us who were hoping to get into the court had to wait about 3 years before a case actually came along. And the first case to go to the court was in approximately 2007, and that was a case that was heard by Sir John Chadwick, a formidable English judge, and that involved a lift subcontractor, if my memory serves me right, who was being sued for their failure to deliver on time. The second case was a case that I was involved in, and that concerned real estate, as you might expect, and that was heard in 2008 by Sir Anthony Coleman. Now the court has a much larger bench of judges. The current tally, if my maths is correct, is something in the region of 12. So there are now 5 UAE judges, 4 UK judges, 2 Australian judges, 1 judge from Scotland, and 1 judge from Malaysia. The court is divided into a court of first instance and a court of appeal. The court is, in its own mind, an international court, and by that it means to encourage lawyers from all over the world to be registered with the court. The court has a list, 2 lists. One list is the list of registered law firms. And as of last year, there were 176 law firms registered to conduct proceedings in the DIFC courts. Those law firms don't actually have to be physically present in the UAE. So there are some law firms that are registered that don't actually have a presence here. And then there's the Part 2 register, which is for advocates. And in 2022, there were 819 advocates registered. The court has a number of divisions. The court has a civil and commercial division, which hears the bulk of commercial disputes, but it also has a technology and construction division, and recently it established a digital economy division as well to deal with disputes arising out of cryptocurrencies and AI and the like. So the court has set its principal objective as being to keep pace, as it were, with the business needs of Dubai. And with that in mind, bearing in mind how international Dubai is and how internationalized it is, its community is, the court has set itself to be technologically advanced as well. And so it's a paperless court, and there's an e-filing system in place. It's been in place for quite a few years. And also a very considerable number of hearings take place remotely as well. But we do have a courtroom, and it does get used, and I encourage you to visit it. So far as the caseload is concerned, in 2022, the total value of cases in the court was 4.4 billion dirham. So quite a sizable volume of disputes, as you can see. The average value of cases was 58 million dirham, so approximately 10 million pounds or $20 million or thereabouts. The court will apply any law chosen by the parties, and in the event that it's impossible to ascertain a mandatory law or a choice of law by the parties, then the court can apply any law that it determines to be connected with the dispute or the parties, and after that it can apply English law, or the law of England and Wales, as it were. But DIFC laws are numerous. Many of them were introduced in 2004 and 2005 and haven't been changed. But there are an awful lot of new laws being introduced every year. The DIFC is made up of the DIFC courts. It's made up of the DIFC authority. There's the Dubai Financial Services Authority as well. And then there's the Legislative Authority, or LegCo. And obviously it's LegCo that is responsible for introducing new laws. The laws that you're likely to come across as a disputes lawyer obviously include the arbitration law of 2008. There was an arbitration law of 2004, but it was revised in 2008. Originally, so far as the courts were concerned, the court had jurisdiction over disputes that concerned the DIFC or concerned DIFC parties. And such was the eagerness of many potential court users to bring themselves within the jurisdiction of the DIFC court. There was, prior to approximately 2014, a phenomenon known as the coffee shop contract, a contract executed in the DIFC over coffee so as to bring the contract within the jurisdiction of the English language DIFC courts. That's no longer necessary because the DIFC courts it's now an opt-in jurisdiction, as is the ADGM. So there's the arbitration law of 2008, which I won't touch on because I think that's somebody else's topic. But we have the DIFC contract law. The DIFC contract, well, Contract law in the DIFC, I think, was for many years misrepresented by the court, actually, and the judges as being English law. I think it was thought that as the DIFC was a common law court, users would want to think that it was English law that would be applied by very often English judges. That's not the case. The DIFC contract law is in fact based on the UNIDROIT principles of international commercial contracts, the 1994 version of that. The UNIDROIT principles have been updated since, but the contract law hasn't been. UNIDROIT didn't provide for everything that the contract law needed to provide for, so there are aspects of the contract law which are not to be found in UNIDROIT, or they weren't then, and that includes, for example, issues concerned with agency. UNIDROIT didn't concern itself with implied and unfair terms in contracts, and so we have an implied and unfair terms law as well in the DIFC, which reflects the English legislation. And there's obviously an insolvency law, an employment law, intellectual property law, any number of laws to cover commercial relations. The Court of Appeal is made up of 3 judges at any given time. The Court of First Instance is a single judge court. There's no automatic right of appeal to the Court of Appeal, like I believe there is in most cases in the onshore courts. You do need to apply for permission. So if you're an English practitioner or indeed a common law practitioner from Hong Kong or Australia or anywhere else, you'll find the DIFC courts very familiar territory. The ADGM courts came a bit later. They came around about 2014, 2015 or thereabouts. They're very similar to the DIFC courts because they are also common law courts. They're styled on the English High Court. They're different in the sense that they don't have any UAE national judges. So they have about 8 judges. They're all from England, Scotland, Australia. At the moment, they don't have any UAE judges. The ADGM doesn't have its own body of law as such, and that's not strictly accurate, but the ADGM is premised on the basis that English common law applies within the ADGM. And in addition, English legislation, specified English legislation, has direct effect, as it were, as the law of the ADGM. And like the DIFC courts, the ADGM courts are comprised of a court of first instance and a court of appeal. I think that's probably enough from me on that topic. And over to our next speaker.
Thank you, Philip. You did both excellently with time. Thank you very much. So after this great introduction to the UAE dispute resolution system and the DIFC dispute resolution, we'll discuss with Andrei what that system has to offer to parties from Russia, parties from the CIS area. Andrei is a dual qualified Russian and English solicitor and is a counsel with Allen & Overy in Dubai. Andrei appears in arbitral proceedings under the ICC, SCC, LCAA, and SIAC rules, and represents clients in litigation at all levels of the Russian courts, as well as foreign courts, including the courts of England and Wales, Switzerland, Cyprus, Jersey, and the BVI. Andrei, the floor is yours.
Thank you. Well, first of all, thanks very much for having me here. It's a real pleasure to be sitting in such a nice office. I'm very new to Dubai. I only moved here some 6 months ago, so I still have 6 months to become an expert, according to Philip. So I'll try to do my best. Speaking of Russia-related disputes, historically, as many people know, many of those disputes would land themselves in London, and there were reasons for that. If you think back in early 90s, when the Soviet Union collapsed and independent Russian Federation and CIS countries and non-CIS countries, former Soviet Union countries, became independent and started opening up for foreign investments, for businesses. At that point in time, international law firms moved into Russia and Ukraine to some extent because they followed their clients. Their clients went to those jurisdictions to establish businesses. Some actually were present there already, like McDonald's, Coca-Cola, for example, and many others. People saw the opportunity and they want their lawyers to be by their side. Russian businesses obviously also needed some support. And at that time in Russia, we didn't even have the civil code, the new civil code until late 1994 and then 1995, the second part of the civil code, which actually dealt with contracts and everything. But the Russian law and Russian courts were very undeveloped back then. So businesses actually needed some legal framework to work with. And there were English firms with English lawyers there who had something to offer. They said, well, English law, it's so predictable. It's basically whatever you write in your contracts is going to be enforced. And as a nice add-on to that, you can get the LCA arbitration or indeed English High Court litigation. So in many transactions dating back early 90s, early 2000s, you would naturally see English law applicable to the contract and English jurisdiction one way or another involved. So it would most often be the LCA arbitration. Quite often that would be English High Court litigation. In addition to that, there was also sort of historical link to Stockholm and Stockholm arbitration, which was very popular with Soviet, East-West Soviet, non-Soviet countries and parties even before the collapse of Soviet Union. So that continued, and SCC was also one of the most popular arbitral institutions. And then you had the ICC for construction, for commercial contracts, and well, you name it. So once the Russian businesses tried English litigation and English arbitration, they were charmed, I think, by people like Philip, who were capable of representing them much better than Russian lawyers could back then, and probably still. And obviously, they were fascinated by the fact that the judges actually heard their cases. So you can have your day, months in court. You can present every single piece of evidence. You can testify there. People loved it, which actually led to a lot of Russia-related litigation, which went way beyond the transactional litigation. There were multiple fraud cases brought by Russian, Ukrainian oligarchs and semi-oligarchs, and not really oligarchs, into London courts. And in the LCA, one thing the Russians and Ukrainians didn't know is that there was not a single case where the claimant was successful. So there were no cases where the fraud claim brought by Russian or Ukrainian investors, or Kazakh investors for that matter, claimants for that matter, actually succeeded, but they paid a lot. So against all of that background, Russian parties didn't really have to look anywhere but to the Western capitals, be it Paris, Zurich, London, Stockholm. But then 2014 came, the Crimea, and first round of sanctions. And at that point in time, the Russian parties, well, some of them were sanctioned pretty heavily, but we now know it was basically vanilla type of sanctions. But at that point, Russian parties became somewhat concerned and started saying, well, they're actually not that welcome in the West for some reason. And at that point, the Eastern institutions such as the SIAC and Hong Kong came to Russia. They toured around, they advertised themselves as sanction-free jurisdictions. They said, we can offer you exactly the same thing as London, but we're sanction-free. And many Russian companies bought into that, and I and many of my colleagues have seen a lot of HKC, SIAC arbitration clauses in the context where you would naturally see the LCA. And Singapore law was chosen instead of English law. Sometimes Hong Kong law, not that common, but Singapore law was considered a very nice substitute for somewhat familiar English law. Then it didn't really bring about multiple cases in one of those institutions, but I have seen a lot of clauses, so the cases would probably come in the nearest future. But then fast forward to 2022. Well, everybody knows what happened there. With my passport, I can't really say much. But whatever happened, happened. The sanctions became more draconian. I think there are very few Russian state-owned companies these days which are not subject to any type of sanctions. Most of them would be under very strict sanctions regimes. But it actually went beyond that. Because when everything happened, and when the law firms started withdrawing from Russia, and when the businesses announced that they're closing down their operations in Russia, a lot of self-sanctioning happened as well. It started after 2014. It started with the banks, which were very concerned with Russian money, but it went way beyond that. So there were cases when the consul would drop their representation in the middle of the hearing. There would be cases where experts would refuse acting for the Russian parties or in relation to the Russian party on the eve of the hearing. There were cases where the arbitrators would resign and say, well, you know what, in the current context, we cannot consider ourselves independent, which actually, from my perspective, was a very right thing for them to do if they didn't consider themselves independent. But anyway, so what we have now is that many Russian businesses, well, some of the Russian businesses had to move elsewhere because operating from Russia now became, let's say, challenging. With all the logistics, which is largely non-existent, with all the problems with cross-border money transfers, and all of that. So some of the businesses actually established some outlets here in Dubai or in the region, in the Middle East. Some of the businesses established operations in wider CIS region, so places like Kazakhstan, Uzbekistan, Azerbaijan, Armenia. Obviously, those businesses who remained in Russia want some place to resolve their disputes. They may not be contracting that much anymore with Western counterparties, but they still have to do cross-border transactions, probably now with China, India, Middle Eastern countries, Southeast Asian parties. So there is still international business going on for both Russia-based companies and the companies based abroad, but with some Russian nexus. And quite obviously, those companies need somewhere to resolve their disputes. Now, the formerly popular institutions like HKIT and Singapore, for some reason, for obvious reason, are not that popular any longer. Now, Singapore introduced some sanctions, very minor ones, but the Russia still considered non-friendly jurisdiction by Russian government. Hong Kong didn't introduce any sanctions, but with all the political, geopolitical pressure from China at various levels, I think it is very difficult for Russian parties to accept that their dispute with the Chinese party would be resolved in Hong Kong, even though technically it's a separate jurisdiction, but you never know how long it's going to be a separate jurisdiction. Now, again, understandably, international partners are not that willing to go to Russian courts or even Russian arbitration institutions, because for them it is pretty difficult. It is pretty difficult to hire counsel there, pay their counsel in Russia, travel to the hearings there. So that's, I guess, that's reciprocal in a way. So what we have is essentially Middle East, which is, and we have to be grateful, and we are grateful, which is very welcoming. As Mr. Ali said, this is a place where everybody is welcome, at least as long as you are a good-minded person. But interestingly, I think it offers not only the hub for Russian businesses or CIS businesses which want to be trading internationally and which want to establish outlets here and work out of this jurisdiction with the jurisdictions in the region. It also offers you pretty much, well, at least to some extent, what Russian businesses admire so much about London ports. You have common law jurisdiction with arguable predictability, where your contracts are enforced as they are written. And a caveat, this might not be always favored by Russian businessmen, because that's sometimes is challenging. Sometimes they would prefer the contracts to be enforced as they were thought about or intended rather than written, but that's a different part of the story. It has a very good logistics. So this is one of the few places where you could still travel from Russia, and from where you could travel to Russia direct. It is the place which can offer very high quality of legal services, starting from this wonderful law firm and all the way to Philip here. So you basically get everything you would get in London, but for rainy weather. Obviously, not every Russian dispute could be resolved here because sanctions are still there. And when the sanctions are there, you have the banks which are unwilling to take Russian money when it comes from an entity or an individual in an SDN list, for example, or in a blocking sanctions list by UK or EU. And that's basically where no jurisdiction probably in the world would help you, because the banks are all now trading internationally. The banks are all willing to be able to transact in US dollars, which means that they, irrespective of where they base, they would respect US sanctions at the very least. And the banks are very risk averse now, as everybody knows, and as every Russian who tried to open an account here knows. But nevertheless, at least part of the challenge that Russian parties face, and part of the challenge which international parties face dealing with Russian, could be removed by having your seat here, having your arbitration administered by DIAC, by one of the regular institutions, or even by Russian Arbitration Center, which hopefully would open up a branch here, because that would be a friendly jurisdiction for the purpose of Russian government. That would be something which is more understandable for Russian courts when it comes to enforcement of your award against a Russian company. And there are huge problems now with enforcement of the LCA, ICC awards in Russia, unfortunately. So if you have, let's say, DIFC-seated arbitration administered by the Russian Arbitration Center, my bet is that for Russian court, that would be an easier go than if you had a Russian party losing in London at the LCA. So from that perspective, this is a very interesting jurisdiction for everybody who wants to be involved with Russia-related disputes, and actually, broadly speaking, CIS-related disputes. So that's, I think, and my time is up. Thank you very much.
Thank you very much, Andrei. I'm told we now have still 10 minutes open for questions. Okay, too much information. Okay, we have from Mark a question.
Back by the Russian institutions in relation to where the Russian courts would assume jurisdiction, notwithstanding the arbitration clause. Do you want to give us a couple of minutes on that?
Sure. Yes. So thank you, Mark. That's a very relevant one. Basically, since 2020, I think, the Russian procedural legislation allows Russian commercial courts to assume jurisdiction in cases where a party is somewhat affected by sanctions. So it's at least with the current jurisprudence, it's not very clear to what extent you must be affected by sanctions. Basically, what Russian courts do now to say now is, okay, there are some sorts of sanctions against this party by somebody, and then by some country, and then the place of arbitration or the arbitral institution or the court selected in your forum selection clause is in one of the countries which introduced some sort of sanction. So Singapore, for that matter, would be captured. Hong Kong wouldn't. So if that is the case, then the Russian party may apply to Russian commercial court and say, you Russian commercial court, please do accept jurisdiction and resolve this dispute on the merit. And if the international party or foreign party wants to pursue their arbitration or commence their arbitration, the Russian court could even issue an anti-suit injunction with a conditional fine, which essentially would be equal to the amount in dispute, payable by a foreign party, plus cost, payable by a foreign party if the foreign party does not abide by the Russian court's prohibition to continue with arbitration. Now, the real question is to what extent this could bite here, because obviously, I don't think somebody tried, but I'm pretty sure you cannot enforce this outside of Russia. There are some companies with assets in Russia, of course, still now. So for them, that would be a challenge. Essentially, what that means is if you are the claimant and you want to commence arbitration against the Russian party, let's say in London, let's take Singapore, which was so popular and still not quite sanction-free, but not too bad. So you want to commence arbitration against the Russian, I don't know, Rosneft in Singapore. Rosneft goes to a Russian court and says, well, no, there are sanctions against us. Singapore is an unfriendly jurisdiction. It's arbitration in an unfriendly jurisdiction. That and yes, by the way, they want us to pay, I don't know, 1 billion. So you Russian court, please order them not to proceed. And if they do not comply, you Russian court, please order them to pay us this 1 billion plus cost. And the Russian court issues this order, ordering whatever Shell, I don't know, ExxonMobil, not to pursue their claim in Singapore, and or alternatively pay 1 billion to Rosneft. So Rosneft is not paying 1 billion. It also has a claim for 1 billion against Exxon or whatever claim there is. So from that perspective, again, Dubai and the IFC and UAE in general is a better choice, because if you can show to the Russian court that the seat is in a jurisdiction which didn't introduce sanctions, that the administering institution is not based in the jurisdiction that introduced sanctions, which would be the case with DIFC seat and DIAC as an administering institution for Russian Arbitration Center for that matter, then, well, at least hopefully, the Russian court would say, sorry, you didn't tick all the boxes in this provision, so I cannot really restrain the foreign party from proceeding against you in Dubai under the DIAC or Russian Arbitration Center rule. So thank you very much, Mark. That was very much to the point. Thank you.
So you raise the prospect of funding. Obviously, we have clients that have issues in actually paying in their Russian origin. Some of them are, some are a little bit, questionable. But I think that is a challenge, because obviously many banks here are very kind of sensitive to that, although there's no restriction, but still we are having issues as to how they may, Russian clients may want to pursue a claim or pay their legal counsel, not because of this kind of issue with sanctions. So is there any solutions that you've seen that work, or how does it work? Because it's a big issue.
Yes, well, I wish I had a solution. It is a big issue, but the problem is that this is a big issue internationally. So there is no jurisdiction where you would not face the same issue. My point was that here, arguably, you have fewer issues than you would have elsewhere. It doesn't mean that you can do whatever you want and you don't face any challenges. I think the way it works, well, I know it's challenging to be getting payments from Russia. I think some people still manage that. The other thing which happens is, as I mentioned, many Russian businesses would establish some sort of outlets either here or in some jurisdictions nearby or in the wider CIS region, let's say Kazakhstan. So if they have operations there, in addition to operations in Russia, my guess would be that at least some banks might be more willing to accept payment from there rather than from Russia. But I take the point, it is a very big challenge, probably the biggest challenge out there.
I'll just add it as a practice today. It's correct. This is the challenge, and I think so. Once time is going ahead, and some banks become more understandable cautiously, because as you are correctly said, that it's all depending on the bank. They are dealing with the dollars transaction, so then they don't want to be that. But I think so the change is because we are on a friendly jurisdiction, and this is the government which they are announced and they are adopting. I think there will be some solutions. I think the solution started with banks to be open here. We have one bank which is already in the media. It's already has been the first Russian bank has been already approved by central bank, and they are operating. That's despite the pressure, I think our government will still need to deal with that. But I think my understanding and my belief is the more time the government here, they will find a better way to service the Russian entities, how to operate here. Part of it, which is the bank, because the most issue is always the bank, because you need to operate on a commercial, you need to have a bank account, facilities, and others. But I see it, as Andrea said correctly, is challenge, but at least less challenge than the other areas of the world. So hopefully we'll see more. I'm positive that there will be lots of other solutions will come on.
No more question. Okay, then I think we just finished our time for the first panel. So at this stage, I thank everyone. I think it was a very excellent introduction to UAE, and we leave the floor to the second panel to Julia and the other panelists. Thank you.
And as far as I understand, we're all here to discuss dispute resolution in the UAE. But for me, as a representative of the arbitral institution, dispute resolution is mostly arbitration. And when we're talking about choosing forum for dispute resolution, I'm thinking about choosing the seat. That's the only thing I think in this moment. So that is why I think we'd better in our session 2, after getting first impression of the UAE jurisdiction, onshore and offshore jurisdictions, we discuss whether the newbies and other companies shall choose, and if yes, why they shall choose the seat of arbitration in the UAE, both onshore and offshore jurisdiction. And if they do, which peculiarities, for example, arbitrators shall take into account when rendering an award. We have 4 great distinguished speakers, so I don't have much time, to be honest, for this introduction section, so I will be quite brief here. Today we have Arin Jayusi, partner at Horizon & Co, Dr. Asama Al-Haj, Doctor of Law, Mark Fraser, Managing Partner of Fraser & Co, and Anne Hoffman, independent experienced arbitrator. And I would like to thank you all for coming again and give the floor to Anne. Why? Because when we are thinking about choosing the seat and about enforcement of awards in the jurisdiction, and there are our main topics today, I think it is very important to remember that first you shall have an award. And first, the award shall be rendered, and it shall be rendered with all of these peculiarities, I'm very sorry, and specific features which are provided by the law and the legislation here. Thank you very much, Anne, for giving the presentation on the topic how to render the award, taking into account the UAE jurisdiction.
Thank you. Yeah. Sorry, is that better? There we go. Was bound to happen, of course. So what I want to talk to you briefly about is the specificities of an arbitration award rendered under the legal regimes here in the UAE, and particular, what might be different from an award, or what arbitrators should consider to make sure that the award is enforceable when it's rendered here, rather than in a jurisdiction you might be more familiar with, Russia, Switzerland, France, or so, because the laws here have, in particular for what we call the onshore arbitrations, established a few features which I think everybody should be aware of when arbitrating, and especially when attempting to render an enforceable award, which of course is the duty of everybody who sits here as an arbitrator. So you have heard that there are essentially, if you want to put it this way, 3 jurisdictions in the UAE. There are the so-called offshore jurisdictions, which are the DIFC, the Dubai International Financial Center, and the ADGM, the Abu Dhabi Global Market. Those 2 are offshore jurisdictions and have their own procedural laws, not only generally, but also when it comes to arbitration. So there are, in the DIFC, there is a special law, which I think dates back to 2008, which speaks to what Philip has said, that, that jurisdiction, the DIFC, had foresight and knew very early on what it had to do in order to be attractive to users of arbitration. That is basically a law which is modeled on the UNCITRAL model law, and similar, but a little bit more expansive, is what the AGM has enacted, which is not what they call a law, but I think they call it the AGM arbitration regulations, also setting out essentially an arbitration law that is modern, easy to use. And frankly, for me, there's not that much to say about that, because what is being said in those laws about what an award should look like is pretty standard and known to all of you. So, the only perhaps more interesting feature for me as an arbitrator when I read this law recently, again, was to see that there's a specific provision in there which says that if the parties haven't paid, you can hold back the award, and you don't have to issue it. That is not something I've seen in a similar way in the ADGM regulations. The ADGM regulations, on the other hand, for example, deal very explicitly and at length with features I didn't expect in a procedural law like that, for example, including what kind of interest can an arbitrator provide for an award and how it should be done, and specifically that it can be, simple or compound interest and factors like that. But apart from that, it is pretty much vanilla standard. The award should be signed by the arbitrators. It should be reasoned, of course, things which you would expect anywhere else too, and has to be rendered at least by a majority of the arbitral tribunal. But a dissenting opinion otherwise is perfectly acceptable. So, when you are seated with your arbitration and in one of those 2 jurisdictions, I do not think that an arbitrator sitting there has to consider anything particularly specific about what he or she should be doing. Now, when we go to the mainland UAE jurisdiction, you have heard that there is a fairly new and much awaited at the time, I can tell you, arbitration law of 2018, which is also largely modeled on the UNCITRAL model law, but as Ali already said, it has in places deviated from that model law. Again, I fully echo Ali that, it is a great step ahead from what we had before. And so I think everybody was grateful to have that, and the practitioners deal with whatever peculiarities, that law may have. What is important, or what's interesting for me in that law about what an arbitration award needs to consider is that as an arbitrator, and that was new to me because I'd never seen that in any other law before around the world where I've arbitrated, is that an award needs to specifically state the nationalities of the arbitrators. So it's something I constantly need to remind myself of, that when I'm sitting with the tribunal, not only do I need to put in that I'm a German national, but I also need to specifically ask my co-arbitrators what nationalities they have when we're in the process of drafting the award. And that shouldn't be forgotten. If I forget, usually the institution, which may be the one at DIAC, is the one that knows and will remind me. But not every other institution might always be aware of that. So if you have chosen, for example, Dubai as a seat of your arbitration, but you also have decided that, you choose the HKIC in Hong Kong as the administering institution, then be aware that those managing that case out of Hong Kong may not be that familiar with the law. For when the Russian Arbitration Center is here, Julia has now, I saw, taken note of it, and will know that that's something arbitrators potentially need to be reminded of. Other interesting features for me as an arbitrator contain a specific provision that in Article 19 that you can, of course, decide on jurisdiction prior to deciding the merits of the dispute. So that is something which, of course, is in line with other jurisdictions. However, what is also featured in there is that such a decision of the arbitrator or the tribunal on jurisdiction can be taken to court within 15 days of that decision being rendered, and is then subject to court review, which should take place in 30 days. That's in Article 19 of the UAE arbitration law. Now, 2 points on that. It has happened to me once that took place, and I can tell you that decision wasn't made in 30 days. And a little survey amongst my colleagues who also regularly sit as arbitrators and have had that has brought about that my colleagues also haven't seen that be decided in 30 days. Now, those who act as counsel and practitioners, I don't know whether you have different experiences, and maybe since that happened, courts have become faster. But unfortunately, this feature means that arbitrations potentially are held up, because what's also in that same provision is that whilst that court's review, if you want to put it this way, takes place, the arbitration generally is stayed. And so everybody is on standstill, and the arbitration cannot progress. And of course, you can imagine that that is something which is a great tool to try and, if not fully derail, then at least to slow down the proceedings. And that is exactly what happened in my case, where the respondent then still found ways after the court's well beyond 30 days, I think it was several months, came back and said, yes, the award on jurisdiction is fine. This party did manage to file some sort of appeal. However, that was possible, nobody knows, because, the rule also clearly says that there is no appeal from that. That didn't affect us. Nobody really understood what that party was able to do in the courts, and asked for a prolonged stay while that was going on. And I said, no, if that, A, I don't understand what you've done, and B, the stay of the proceedings is clearly only foreseen for the time in which the court is deciding on whether this jurisdictional decision is correct. And so therefore, even if something is going on in the courts further, that's not something which will stay the proceedings. So there's a tool by which, delay can occur unless a party clearly says they want to continue the arbitration proceeding. So by default, the arbitration is going to be stayed during that time. But a party can request that the arbitration continue. In my case, for example, that didn't happen. I also understand that in many other cases that doesn't happen, because I do think parties are slightly afraid of speeding ahead, especially if the courts are not only taking 30 days, but longer. So you imagine you've gone almost down the road of, getting into, hearings on the merits, etc. And then the court potentially finds that, the decision on jurisdiction was incorrect and overturns that. So this is something I think people need to be aware of, and arbitrators need to be very aware of when making awards on jurisdiction, that this is what can happen as a next step. The law now also clearly sets out that you can or arbitrators can issue also provisional and or interim and partial awards. That is something which was hotly debated and questions under the old law in Dubai or in the UAE. And you had interesting situations where if a tribe or jurisprudence on that point, which then scared parties to even, or tribunals to even do that, because courts had found that once an award was rendered, the tribunal no longer was in function and no longer was in office. Now, that means you had dealt with the partial aspect of the arbitration. And then a clever respondent had gone and said, but look, here's the award. And because there was no clear concept under the old law about interim and partial awards, etc., the jurisprudence came back and the courts came back and said, yep, there's an award, the arbitration is over, you tribunal have done your job. And everybody stood there and said, but we're not finished, and so that led to upheaval in arbitrations, and that issue has been clarified and fixed, luckily. Similar to the other laws you will be familiar with, otherwise, apart from the nationality issue, you need to sign the award. You need to reason the award. The majority decides, i.e., if one arbitrator dissents, then the two other arbitrators are able to render an enforceable award. Interestingly, a feature which I hadn't seen before either is that if all three arbitrators can't agree with each other, then the president or the chair of the tribunal decides. So that is interesting. I've never seen three arbitrators not agreeing at all. I mean, usually, two find each other somehow and are able to form a majority. But that is an interesting feature. One last point I want to make is that there are clear timelines in this law, which is, I think, also slightly unusual as to when an award has to be rendered. And in Article 42 of the UAE arbitration law, it is stated that the final award shall be rendered subject to the agreement of the parties. Otherwise, one has to specify, but I'm coming to that. But otherwise, the award shall be issued within 6 months from the date of the first hearing. Now, that is interesting because, well, the first hearing, could be the case management conference, but I have had cases where tribunals, haven't really had a first hearing because parties sort of largely agreed on everything and said, you know what, we don't want to incur the costs of having the tribunal turn up for this hearing. Let's just proceed on the basis of the procedure order, the first procedure order, and the timetable, which is there. So you never have a first hearing, or the first hearing will be the one on the merits. Now that is fine for a 6 months, award to be rendered, or a 6 months time frame for the award. Otherwise, the law permits that if the parties haven't agreed otherwise, the tribunal can extend it for 6 months, which gives you a year from the first hearing. Now, again, for any big arbitration, in my view, that is kind of impossible. And you find yourself in the unfortunate situation that you either depend on the agreement of the parties to extend it, and then that's fine. And otherwise, after that first year, you have to go and apply to the courts for either the arbitration, the time frame to be extended, or the arbitration to be discontinued. Everything, I think, will be fine in a classic arbitration, or, well, I shouldn't say classic because what's classic these days, but in an arbitration where parties cooperate well and everybody is interested in getting the dispute resolved quickly. But when you have a respondent who isn't interested in that, in a particular case, my worry would be a case where the respondent doesn't participate at all. A respondent might actually choose not to say anything at all throughout the entire case, and then come up when the deadline is come and said, well, we haven't agreed to anything else. And here we now go to the courts and try to derail these proceedings. So that is something where I think, this rule, I think, come about with the best intentions to make arbitration procedures efficient and fast. might actually give rise to guerrilla tactics and concern. These are the features I think one wants to maybe have a closer look at when arbitrating, and which I think in particular arbitrators need to be aware of when attempting to render an enforceable award. Thank you.
Thank you very much. And it's a tricky question. So, for example, if both parties didn't object to ICO? No? Okay. Maybe, yeah. It is on. Oh, I'm sorry. If neither party objected during the proceedings, and then in the end, any of them finally objects. So do arbitrators really do something with it? I mean, do they terminate the proceedings without rendering any words, or they just suppose that parties had already implicitly agreed during the whole proceedings after the PO number 1, after the CMC and everything, they just implicitly agreed?
So, you know, you're right. And as I said, in my view, this really is a problem only in cases where you have a respondent who's really trying to be difficult, and potentially you have no institution. Now, normally you would have probably an institution in there, and then you have institutional rules, and they have other provisions in there, you know, for example, the old DAG rules, etc., which handle it slightly differently. And I think those potentially overtake this provision. And in any event, as long as you have an agreed timetable, which everybody was working with and everybody agreed to, then I think that, you're right, is an agreement to have a wider time frame and be able to continue these arbitrations longer. I wouldn't then, as an arbitrator, specifically go and say, look, just to make sure we've all agreed this timetable, we all know what's going on, can I just check with you on RTD? I wouldn't do that. But my worry are cases where the respondent hasn't done anything like this, hasn't surfaced the entire time, but then uses this provision. And it may be fine in the end because the courts then make the right, you know, decision. But at least, you know, you find yourself in the unfortunate situation that it may then go to the courts, and people are trying to play with this provision and give you, as the claimant, who is of course waiting for, you know, an enforceable award to come quickly, give you a hard time. So I would hope that, you know, in the end, everything would be fine, but you can see how this provision and unfortunate circumstances may be used to at least delay the proceedings and make it more difficult for the claimant.
So if it is possible to avoid any like technical problems and details, it is better to do that.
Of course.
Thank you so much, Han. It was very interesting. And now I just wanted to give the floor to Erin to speak more about how these peculiarities and whether these peculiarities can really affect somehow the enforcement process of domestic awards. So the awards seated in the UAE, onshore UAE, and to give the practical perspective, because Erin is a very experienced lawyer in dispute resolution, is a partner of Horizons & Co. with a decade of diverse experience in both arbitration and litigation, different areas, including the UAE.
Thank you. Unfortunately, I got older, so it's now 15 years. No longer a decade, but
I have a decade here.
I know, yes, thank you. I will be speaking to Chris over there afterwards. But no, thank you for the introduction, and thank you all for coming, and I welcome you once again. I know Mr. Ali and the co-panelists of his panel have already done so, but it's very nice to see you all here today. Onshore arbitration litigation related matters are what we do and we specialize in. So you won't be surprised to know that the local law firm is passionate and loves local law, but we really do at Horizons & Co. So anything we talk about in relation to both arbitration and litigation is very much our thing. I do believe that if you want to be very good at arbitration, you also have to know litigation pretty well, particularly when you're enforcing an award, of course. I agree with my respected colleague Anne and everything that she said about the new law, which we were all very excited for in 2018. For those of you in the crowd that are lucky enough to be, have been around before 2018, you'd have all shared our frustration at the regime at the time, in relation to arbitration generally, just a few very generic almost articles in the civil code, to what we have today, which is a fully fledged, to our onshore view, is a very robust, very good piece of legislation that we can rely on, both for the conduct of proceedings and also afterwards for the enforcement of an award. So although I agree with the points Anne very eloquently put, we find it as a major step forward and almost as if you're pressing fast forward on the proceedings. I was lucky enough to have an arbitration case prior to the law where I was an arbitrator, and it was painful. It was long. It was drawn out. Guerrilla tactics were used almost on a daily basis. That so much nowadays, if I can be frank, is not so much of a thing. It's not possible now, and I'm very thankful for that for the legislator in the UAE, and I do believe we're all in a better place as litigators and arbitrators because of it. We always say, and this is famously what Mr. Ali says when he meets a client, there's no point doing a case if you can't enforce it. And I think clients in the UAE are very aware of that, more so perhaps than in other jurisdictions. Because if you go through a long, laborious process and it has no teeth, you can't enforce it. You've wasted money, you've wasted time for no reason. That's why here at this law firm, and we as practitioners always, almost at the very beginning of the process, either do due diligence and categorize very clearly how you can enforce an award, because we don't want a hollow award in these proceedings. So when we're talking about onshore enforcement related to the point we've just mentioned, the new law greatly assists the efficiency and the speed of the process. You will all know, I'm sure, that the new law has introduced a specific provision that allows you to skip the very lengthy process of ratification and enforcement of an award at the CFI, the Court of First Instance, and you can now go directly to the Court of Appeal, saving lots of time, lots of effort for all parties involved. That was a major step forward from our local law litigation perspective. Anne's already spoken very eloquently about how and why an award can be challenged in the law, generally speaking, so I won't repeat those, but we again welcome those changes as a major improvement and amelioration of the arbitration environment in the UAE. I remember when I first set foot here in 2008, when the DIOC law enacted its Arbitration Act, and we were still waiting and waiting and waiting for the arbitration law here in onshore UAE. It was a very different landscape. Arbitration was a very different place. I'm very happy now with the arbitration-friendly environment that UAE has garnered. And if you come here in Arbitration Week, which my esteemed panel are very active at, you will see and feel the vibrancy and the dynamism of the industry. And that's all due, in my personal belief, to the legislation changes and amendments that have garnered that type of environment, and something that we very much welcome. Onshore enforcement has become, from our perspective and from our discipline, an easy task as compared to years ago. Years ago, a counterparty or a disgruntled party that was not happy with an adverse award would very easily, procedurally, challenge an award for very lax reasons, for reasons that you wouldn't expect in other jurisdictions at that time. I'm happy to say that nowadays it's far more difficult to frustrate the process in that way. It still happens, as Anne very correctly said, but it's far, far more difficult. And I think practitioners are all in unison agreeing on that point. Of course, everything is not perfect. We don't live in a perfect world. Even lawyers, we always think we are perfect at what we do and as people, but generally speaking, we're in a far, far better place. Enforcement, of course, requires a keen knowledge of the local system. I don't even want to say law here, because you need to know the mechanisms of enforcement at the local onshore courts. And that's something that we obviously specialize in, and we have strength in, simply because we speak, both languages. We also have a lengthy experience with enforcement in general, local law in general. So we try very much, and I'm happy to say we're successful at, marrying the two divisions in our law firm, arbitration and litigation. So our clients do feel that when I have an award from a tribunal, it's actually going to be enforced in an expedient, an effective and practical manner. Without the local knowledge, without the court knowledge of how these processes actually go ahead and how they are finalized, there would be major stumbling blocks in the way. And that's what I think is important, particularly for this discussion.
Now, for example, what tell people that the work was rendered 6 months and 3 days after the first hearing? It won't be the visa, the ground, criminal.
Well, it could be. I think Anna touched upon that. So if the parties and the tribunal don't request an extension, so that each obviously centre has slightly different rules. The DIAC is very clear in its rules for the extension of the time frame, the 6 months time frame. But of course, it could be potentially used if the procedure has not been followed to annul an award. Generally speaking, of course, arbitrators and practitioners are very aware of the time frame, and they do everything that they can to extend it correctly with the agreement of the parties, as Anna was saying, and obviously unilaterally by the arbitrator, as the direct rules states, can apply and get it extended. But that's obviously one of the first things you look at on your checklist to ensure the veracity and the soundness of your award. That's one of the first points on. Yes. No, of course. Yeah, yes, indeed. Here in Dubai, generally, people like things to happen quickly. Everyone will know that here. So it's a very dynamic place and very efficient place to get things done. Arbitration shouldn't always be done quickly, I don't think, in my personal opinion, because some of the merit-based arguments are complex and protracted. But definitely some of the cases that I get are very basic. Some real estate cases that perhaps when a purchaser has paid the full purchase price, by way of example, it just simply hasn't received the unit. I don't think it needs to go, in most cases, past the 6 month time frame. So it really does depend on the type of case that's before a tribunal or before the sole arbitrator. But we welcome the 6 months time limit because it was really abused. And again, that's something that people will know. Prior to the legislation amendments and changes, respondents would really kind of protract proceedings on purpose.
I agree. It very much depends on the case, because a lot of cases can be resolved quite quickly.
Mm-hmm.
For example, in the Russian Arbitration Centers, there are some even cases during 90 days in expedited procedure, and sometimes it works really.
Yeah.
But yes, not too often. So, okay. If we choose the UAE as the city, as far as I understand, as far as we discussed, usually there are not so many problems now. I mean, after the new law was adopted. But what about enforcement of foreign awards and foreign decisions? Dr. Asamo, what would you say? Is it now easy to enforce the foreign awards in the UAE? Now seated here.
First of all, thank you so much for giving me this opportunity. And I thank Ustaz Ali and Horizon and Russian Arbitration Center for this very interesting topic. Yes, the foreign arbitration awards as well as the foreign judgments enforceable in UAE. And the civil code, which has been changed recently and came into force in 2nd of March 2023, covered this obviously in many articles. And the things that we can see is adopted most of the conventions that before we relying on it in the court after we need to prove it. For the reason that's not covered under the laws. So this is one of the things that I can realize it. That's, Riyadh Convention, GCC Convention for Enforcement, as well as New York Convention and UN. All these being covered almost with this articles in the Civil Procedure Act. Enforcing this for engagement now became very easy and well organized, like what my colleague, respected colleague, Arin said. Before, we are suffering a lot to get it done because, you know, every judge, every concept has its own interpretation for this arbitral award or the foreign judgment. But now it's very clear, straightforward. There is features being specified in the civil code that one of it is it has to be a final judgment, executable in the court that the country were issued. Secondly, you know, the parties should be summoned and you know, given the chance to represent it properly and, you know, with a proof, as well as the UAE courts does not have the jurisdiction over the specific merits or the differences. And other 2 or 3 procedural issues, which is very clear now for the judges, for the parties as well. We have the arbitral award. The good thing is that in the civil code right now, both arbitral award, foreign, I mean, and as well as the foreign judgment, same provisions applied. So this means that it's became really like what Arin said, it is arbitration friendly. But now I can see from my experience that a lot of arbitration foreign judgments easily being enforced, and whether it's onshore or with offshore courts, very easy. Yes, there is some disputes or discussions about the conflict of jurisdictions. This mainly for me as in-house, it's related to the clause of the arbitration, the clause of the jurisdiction and the governing law. So for me, it's very important, and you know, I'm sure Irene, you know, you look at it from different.
Yes.
But you know, for me, when I look to any agreements, I'm looking to mainly what will be the governing law and the jurisdiction, and whether it's arbitration, is it the IFC, is it UK laws, is it local laws, is it something different? So this will guide to the best enforcement, you know, of the such arbitration award. This, in my opinion. You know, because, you know, when you look at it from the arbitration tribunal until you get the award, it's easy, it's a procedural and can be done like Anna specified. But to enforce it, it's a matter of, you know, because every client you want the money back. Enforce it depends on the clause in the every and each agreement. You have to look at it. Recently, not recently, it's 2016 almost, there is a tribunal, they call it a joint tribunal committee. This tribunal being, you know, started in 2016. The reason behind that is the conflict of jurisdictions between the IFC, because most of these, you know, creators, they're using the IFC as shortcut and to get enforcement of the foreign arbitration awards, and then come into the onshore to get it done. So because of the protocol between the Dubai courts and the DFC courts, this now became a little bit, you know, challenged, because some of the debtors going to the Dubai court at the same time and trying to nullify these awards. When a dispute like that happened, I think it's 8 judges being appointed from both courts, looking to the jurisdictions and the conflict of jurisdictions in that way. It helped a lot. It has, you know, now more than almost 50 or more presidents looking to these jurisdictions, and they have very good judgments, you know, to resolve this matter. This is in general, you know, the arbitration. we can take from this that enforcement of a foreign judgment and as well as foreign arbitration award, it became more easy, well organized under the UAE laws and the UAE new laws, comparing to the earlier time. So I think in Russian Center, Arbitration Center, to be more easy for them, to adapt their rules and regulations within the market, not because of, you have different regulation, but because you have a very well organized infrastructure, legal infrastructure in UAE. This is in a nutshell. Thank you.
Just to clarify, in different jurisdictions, sometimes there is a case when it's much more difficult to enforce foreign awards than domestic awards.
Yeah.
Even if, of course, these countries are the bodies of the EU Convention, but of course it is much more difficult. I mean, practically, not according to the legislation. It is not a case in the UAE, am I right?
Yes, it's not a case with, we can slightly say that, but, every case is not enforceable in the country where it has been issued there, a judgment, it will not be enforced in UAE. But one of the reasons that they are using it as a criteria to evaluate these judgments is that looking at, is it enforceable in the country that from where it's been issued? Sometimes not only enforceable, sometimes the topic itself, it's against the public order, against the moral or something like that, which is also not enforceable in UAE, as well as the topic itself is not subject to arbitration, should not be rendered to, should not be sent to the arbitration. This is one of the reasons that they cannot accept it in UAE. So there is some criteria and requirements has to be there, and one of it is this, like what you said correctly.
Thank you so much. Thank you so much for this event. Okay, so another topic I think we shall discuss as well, according our agenda, is that the UAE is a quite unique. Also discussed today that there is quite significant difference between them. Dear Mark, can I ask you to maybe to focus on offshore jurisdictions, because Anne already mentioned it with regard to rendering the awards, but I think it's very important to understand how to enforce an award here. Thank you.
Good afternoon, everyone. Essentially, in the time available now, I'm going to touch on recognition and enforcement of financial zone awards, and then look a little bit more in depth at some of the on recognition and enforcement of DIFC, AGM awards. Procedure is pretty much the same. But you have a blend of the DIFC and arbitration law and the local court arbitration procedure. And it's pretty streamlined, and I think I can echo positive by in that the approach to DIFC kind of mirrors each New York convention which applies arbitral awards. Is that better? To make these awards enforceable essentially worldwide. So DIFC, under Article 42(1) of the DIFC arbitration law, you make an application to the court, witness statement attaching either the original or certified copy of the arbitral award and the arbitration agreement. And if the court thinks the award is suitable for recognition, it will make an order to that effect. In the DIFC, you can make that application with or without notice to the other side. And if you get the decision in your favor, off you go and you serve the DIFC court order on the other party. Very similar procedure in the ADGM. Part 4 of the ADGM arbitration regulations of 2015 regulate the position. And again, you don't need a witness statement, but you provide either the original or a certified copy of the arbitral agreement, and even a copy of the arbitration agreement itself will suffice. The right to challenge on the side of the other side really follows Article 5 of the New York Convention. And broadly speaking, we're talking about either a violation of the right to due process or public policy. We heard, I think, earlier on, the UAE is a signatory of the New York Convention. It's also a party to the Riyadh Convention and the GCC Convention. So the process for recognition and enforcement of foreign awards is very much like the process that I outlined earlier on. Conduit jurisdictions. Now, this has been a source of controversy for years, particularly starting off in the DIFC. The idea that you have your foreign award, you're concerned about difficulties of enforcing that, and so you go in and you seek to use a user-friendly jurisdiction to get around those difficulties. But what's the state of play in the DIFC and the ADGM today? We heard earlier that there is a joint judicial committee, and it's made up of a mix of DIFC members and local Dubai court members, with the Chief Justice of the Court of Cassation as the chairman. And its role is essentially to decide where there's a conflict of jurisdiction, which court should have prevalence. And the Joint Judicial Committee considers that the Dubai onshore courts have, I'll just quote, general jurisdiction under general principles of law embodied in the procedural laws. So with the makeup of that committee and that statement that Dubai onshore courts have general jurisdiction under general principles of law embodied in procedural laws, a lot of people thought that was the death knell of conduit jurisdictions. But I'm just going to look at two cases which show the approaches that have been taken. And essentially, the cases have to be looked at on the facts and will be heavily dependent on those facts. Now, the first case, Sinbad Marine versus Essam Al Tamimi. Now, Ali, I think that name rings a bell somewhere. Now, in this one, the DIFC courts were held to have jurisdiction. The facts were fairly straightforward. Mr. Tamimi had a very nice yacht. He wanted to have it renovated. The arbitration agreement in the contract provided for onshore Dubai as the seat, but the governing institutional rules were the rules of the then DIFC LCIA. Mr. Tamimi thought, I've succeeded in getting my award, but what I'll do is I'll go for the DIFC recognition with a view to then going onshore to enforce in onshore Dubai. The other side didn't like that idea, so they went for nullification setting aside in the local courts and said, well, the seat of the arbitration's onshore Dubai, so that the DIFC should not have jurisdiction. Surprisingly, the committee found that the DIFC courts were competent to recognize the award on the basis that the DIFC LCIA had been set up in the DIFC, therefore the supervising court of the arbitration should be the DIFC courts, notwithstanding the seat of arbitration being onshore Dubai. The dissenting minority of the DIFC members, 3 members from the DIFC, they said, well, actually, there's no conflict of jurisdiction here, and we're talking about setting aside the award. International arbitration, a core principle is that the appropriate court is the one of the seat of the arbitration. So interestingly, we have a dissenting DIFC group saying it should be onshore Dubai courts. And in that case, I've been told I've got 1 minute. In that case, the majority went and said, no, DIFC jurisdiction. And let me then quickly spin through a case that I actually gave some advice on around the edges. Akhmedov v. Akhmedov and Straight Establishment. This is the cracker. One of the oligarch asset tracing divorce cases. So Mrs. Akhmedov, she'd fallen out with her husband, and she gets an English family court judgment, and then she goes looking for the assets. The reason for Straight Establishment, it's a Liechtenstein company, and it's holding a super yacht, MV Luna, on trust for Mr. Akhmedov. So that explains the dramatis personae in the case. We then got a multiplicity of proceedings. Mrs. Akhmedov went to the DIFC for a freezing order against the yacht. She also went to the Dubai courts for a precautionary court attachment, thereby maintaining the yacht in, I think it was Port Rashid, just down the road. Straight Establishment thought, well, hang on, we shouldn't be involved in this. We weren't a party to the English court judgment. So the DIFC courts don't have jurisdiction over us in relation to an English matrimonial judgment and a DIFC freezing order based on that. So they appealed. Now, Mr. Akhmedov, he really liked his yacht, probably more than the former Mrs. Akhmedov at this point. So he decided, I'm going into the Dubai courts, and on public order, public policy grounds, he argued that the DIFC courts didn't have jurisdiction to make a freezing order over an asset in onshore Dubai. So the stage was set. We've got multiplicity of proceedings, the potential for inconsistent findings, perfect for the committee to make a decision on. So all those proceedings were stayed and over to the committee. So they sat and looked at it, and they came to a quick decision. They said, pragmatically, we really need one court to look at this, to entertain the whole dispute. And as the Dubai courts have general jurisdiction, they're the appropriate court to take this matter on and to decide it. So in that case, it went to the Dubai courts. So in the Abu Dhabi global market, very quickly, they've decided we're not getting involved in this controversy. And in 2020, they decided you can't use the Abu Dhabi courts for conduit jurisdiction purposes. But in Dubai, in DIFC, I would say it's still alive, heavily dependent on the facts. I would proceed with caution if you're thinking of doing it, but just drawing on the very positive comments that have been made today. The new law, the 2018 law, is very positive. It's cured a lot of the issues. And to the extent that that really has solved a lot of these problems, I would have thought it's going to be an unusual case where you consider going and using the DIFC as a conduit jurisdiction. So I think that would be the state of play, not ADGM, possibly DIFC, but go cautiously, and it'll be very fact specific.
Mark, you already moved to the issue. I just wanted to have great experience and expertise in it. It is your practical stories and cases and anecdotes from your practice. So who would like to start? Maybe Irene, do you have any interesting cases with regard to enforcement of domestic awards in onshore?
Not as exciting as yachts and billionaires, unfortunately. We've had some interesting cases in this firm. Unfortunately, we can't divulge the names of the parties, but I mean, we're used to dealing with local disputes. Some of the very not so interesting in terms of the details or the quantum, but many a time we deal with disputes between large families. So when we have, and when I say large families, of course, I'm talking about the well-known families that have quite a lot of wealth in this jurisdiction. it can be very interesting when there's some infighting between heirs and people that take inheritance, particularly when the court issue is finalized, and then there are some commercial issues that have not been finalized, and arbitration is then pursued. When it comes to the award, challenges are very interesting because, as we discussed previously, challenges are now very difficult to make if they're not within the very stipulated for parts of the law. But people are very take things very personal. So you see, when you see sometimes the enforcement statement, when you go to the court and try to enforce, you find very strange things in this part of the world that are listed there. You find things that you wouldn't perhaps find in other jurisdictions. You find accusations that this person has this amount of money in this bank account, which is of course not true. You find things of that nature, which we find quite interesting. Cases of note, of course, are well known. Doctor spoke about public policy, which is something that we also have dealt with in this office. Public policy, very famously, is not defined in UAE law. So it can be as wide as it wants to be, and it can be as narrow as it wants to be. One of the major kind of trailblazing cases many years ago was in relation to real estate. So when an arbitration case had come to an end, an award was issued and was being enforced in relation to the registration of real estate, that was seen as a very sensitive public policy arrangement in the Emirates of Dubai, and it's very famously annulled, and enforcement did not happen. Of course, things have moved on from there, but enforcement is always a very sensitive subject in relation to public policy, where the elements of what is concerned Emirates specific is sensitive. In Dubai, as you can see, if you just look out the window, large segments of the economy are based on real estate, and on construction and on hospitality. So those areas, if the Emirates of Dubai feels that the enforcement is encroaching on what is theirs, public policy arguments can scupper enforcement processes. So those are the interesting things that we've dealt with. Unfortunately, again, major big divorce cases we don't tend to see, and yachts in Port Rashid or in the marina are something that our esteemed colleagues get the privilege to see. We get family disputes and things of that nature.
Thank you. That's the point, the weak point of I think a lot of different legislations, because I saw Catherine, my colleague, like smiling when you start talking about public policy.
Yeah.
So is it a most popular ground for annulment?
It definitely used to be, because when this case came about, the one that I'm talking about, everybody jumped on the bandwagon. There was 100 articles from law firms at the time saying public policy is threatening the arbitration climate in Dubai. It's a problem, I'm sure, and you remember those days. Lots has changed since then. Public policy is now narrow because it suits the arbitration scene, I believe. When it doesn't, then things perhaps may change. Dubai is a glorious place to live and do business and to do arbitration. So the arbitration-friendly environment that we've all been speaking of lends to the general trend that public policy isn't to be used to scupper or to delay or to in any way be negative towards the environment, the arbitration environment. But of course, it's a changing beast, public policy. It can change with the political environment. It can change with societal shifts. As the co-panelists in the previous session said, legislation changes here happen very quickly. We saw over 50 pieces of law change overnight. We saw major pieces of legislation that affect how we all live here change very rapidly. So public policy is an interesting subject and something that we, as a local law firm, specialize in and look at quite frequently. So it can be used, but is infrequently used at the moment for challenges.
I can add
what Arin, from an experience that, now we're moving as the challenges for such arbitrations, specifically based on the Sharia or Islamic Sharia, I mean, and some transactions, either the parties will agree that it will be based on Islamic Sharia principles, or it can be issued and under this umbrella. So instead of the public policy now, it's a trend of nullifying this arbitration awards. Now they're using it's not Sharia compliant.
Yeah.
So it's part of the public policy issue, but they're looking to it from a different and there is 2, 3, 4 cases, which are big cases.
Interesting.
Yeah, and it's the court reached a judgment saying that yes, it is not a Sharia pregnant, and then render it's either dismiss the case or consider it as a different things. So this is one of the things that to add for the public policy now, or the defenses that can be raised as well.
Thank you. And Mark, do you have any comments on that? Maybe it's like some cases where arbitrator shall take it.
I haven't got anything with regards to public policy, unless Mark wants to immediately say something about public policy. No, and of course, once my awards are off my desk, I don't really see anymore what's going on with them. Luckily, often, and unless I'm told anecdotally about, I meet judges who say, "Oh, I've just seen your award," and I'm like, "Oh, that happens every now and then." But of course. And I didn't have time before to say that, beyond what's written in the arbitration laws on and offshore here in the UAE, one needs to have regard to the jurisprudence that comes out of the courts.
Yeah.
And they are, of course, crucial. And of course, I think many of you have heard about the horror stories about, an award seated or in an arbitration seated in Dubai. The award had to be physically signed in Dubai. So in international arbitrations, arbitrators had to fly in from all corners of the globe, meet somewhere, sign the award, then to go back. I don't need to tell anybody that this is, a waste of time and money, and made life very difficult in terms of, also being considered an arbitration funded jurisdiction. Now, that has been clearly clarified in the most recent UAE arbitration law, like that an award is deemed to have been made at the place, regardless of where the signatures were put by the arbitrators, and even accepting electronic signatures. So a major step forward. But what has unfortunately come back, and I remember us talking about this, Irene, at some point, is that the slightly burdensome, especially when you have a long award, need to sign every single page of an award. And we were very much hoping that with the new law, we would open a new chapter. But unfortunately, the courts have clarified that they don't understand why, since the wording of the provision is not much different than the wording of the previous law in this regard, why we should be doing anything differently. Right. And so I think, but I'm leaving it to the more locally astute, also dealing with court practitioners here to explain it. But I think this came about from a decision which said, if the reasoning, the dispositive part of the award is on a separate page than the reasoning of the award, then everything has to be signed, or every single page has to be signed. Now that has taken on a life of its own, and now everybody, even if that is not the case, even if the dispositive part is linked to the reasoning on the same page, everybody out of caution signs every single page. Sometimes also in DIFC or ADGM seated cases, with the view to make sure that the enforcement is secured. And I've even seen practitioners making sure that the terms of reference, if you have any, are being signed on every single page. So that's slightly unfortunate. I think there was hope that at some point maybe a Court of Cassation judgment would clarify that and say this is no longer necessary. But exactly, up until now, it's there. And the second issue you have, if you rely on the law purely, and you don't have institutional rules, which maybe have different provisions. So if, for example, you have an ad hoc arbitration seated in Dubai, is that, again, we had in DIAC arbitrations for a while an issue about costs and whether the tribunal can award the legal fees of the legal representatives. And it found that because of the wording of the DIAC rules, that wasn't the case. And unfortunately, the UAE arbitration law also doesn't list when it comes, it says in an award, and I didn't specifically say that because one of those vanilla clauses which you find everywhere is that an award has to make a decision on costs. And it says, in other places, and for example, in the DIFC law and in the ADGM arbitration law or regulation, it says costs also includes the legal fees. Unfortunately, the UAE law missed that point.
Yes.
And therefore, we're back that unless you now arbitrate under the DIAC rules, which have also now clarified that point, or you have any other institutional rules, you need to be aware of this. And the way that if you haven't specified this in any other way, you have an issue ultimately claiming legal fees. If you don't have institutional rules which clarify that, then the way around this, which practitioners here for a long time have done, is to put a clause to this effect in your procedure order number 1 or the terms of reference, whatever you're rendering. But of course, that means the other side, the respondent, needs to agree to that, or both parties need to agree to that. And I've seen cases where the respondent usually doesn't agree to this, and then you're stuck, and that's a problem. So this is something which is by way of case law, which arbitrators and parties need to be aware of when rendering awards.
Thank you, Mark. Chad.
Just on Anne's point there, I've just finished sitting on a tribunal on an ad hoc case, and substantial legal fees were not recoverable as a result of that. Anecdotally, if I could skip, I can give you an anecdote, but I'm seeing an opportunity to get some free legal advice here. So I can maybe pursue one point. Challenging a DIAC award on the basis that the sole arbitrator did not or dealt with issues which were not before him and which clearly informed his decision and had not been put to the parties. Would that be a valid ground for challenge?
It should be. Article 15 onwards deal with that, as we all know. We've actually used that successfully in this office. So our arbitrator not dealing with something that was pleaded is definitely something that you can use, with obviously varying degrees of success based on the merits and based on the arguments, but that's definitely something that's captured within the law and is something that we have used successfully.
Thank you, that gives comfort. In terms of an anecdote, it touches on a name that Philip raised in the first session. And this was an unusual one. It was pre the Joint Committee on Conduit Jurisdiction. And it was just in the post-Banyan Tree days.
Yes.
And it was a real estate arbitration. We secured quite a juicy award against one of the master developers in Dubai. And I just thought, over to the client's local lawyers for enforcement. On you go. And then I was asked to join in a meeting, and someone was dreaming up this idea that we'll use the Banyan Tree Conduit Jurisdiction approach for a domestic award because it'll be a bit easier and we'll get past all those problems. And I was never convinced when I heard it that people wanted to go down this route, and I duly rocked up in the DIFC before Mr. Chadwick that you mentioned. Now, I don't know, and I'm not here to assassinate characters, but Mr. Chadwick could be a difficult man. Sir John could be a difficult man. And I caught him in one of his difficult days. And because the other side had raised annulment proceedings, he felt, well, no, I can't look at this just now, deal with them and come back. And I used that as an opportunity to say, let's just go the normal route. It's a domestic award. Let's get the local guys to enforce it, which actually worked in the end of the day. So it's anecdotal, hopefully topical. And it's all been cured now by the Joint Committee, which seems to be doing its job reasonably well.
Thank you so much. So we just have 3 or 4 minutes left, maybe even less. So I have one final question about the sanctions. During the first session, the speakers were quite anonymously, they told us that sanctions don't affect Russian business in general. But my question is, do they affect somehow the enforcement process? Because for many companies and for many claimants, it is a big problem in different jurisdiction, which cannot be decided by just choosing another counsel, unfortunately. Maybe Erin or Mark?
Yeah, so I think as the previous panel discussed briefly, sanctions is a complex issue because it has various different levels. It has a international level and it has a domestic level. And also in between those, there are certain levels of complexity. From a UAE legal perspective, the UAE does not like sanctions, just generally speaking. Not just in particular in relation to this particular conflict that's ongoing now, which we all hope will end soon, but even for its own regional issues. This is obviously not a political forum, it's a legal one, but the UAE has its political agenda and it has its political issues, but doesn't like the idea of sanctions. A very often referred to example is its dispute with Iran, yet it's very welcoming to Iranian businesses. And many a party can come here, Iranian party, state or otherwise, can have access to the courts, have access to arbitration tribunals, and get awards and get judgments and enforce them. We have experience with that in this law firm, and I'm sure many other law firms have a similar experience. So just generally speaking, from a local law perspective, sanctions are almost the antithesis of what the UAE stands for, which is commerce, bringing people together to do business. It's a commerce hub and a cultural hub. So that's a starting point that we must understand here when we're practicing. But of course, I think as I believe it was Andre who mentioned, there is international pressure on every single jurisdiction, unfortunately, at this stage. So that also has a part to play in the enforcement regime here, and just generally speaking on how people do business. But there are no formal sanctions on a domestic level against Russian entities, banks, businesses, individuals, and that's obviously very clearly seen as many Russians have been welcomed here in terms of businesses and high net worth individuals and just lay people, right, normal people. So its impact on enforcement. Right now, as we speak, we are inundated with both sides of the fence. So we have Russian entities, individuals saying, we're getting very unfair judgments against us in Europe, predominantly Europe, where they are getting judgments ex parte and then enforcing it all across the world. The question is, can they do so in the UAE or particularly in Dubai? The answer is, of course, as we've discussed and as Dr. touched upon, that's a possibility for them. But they must obviously follow the procedure and follow the law. In other jurisdictions, we've seen because of the political environment, and we feel unfairly, Russian assets have been seized, taken, etc., in a different way. Our answer here in the UAE is they must follow the procedure, they must follow the law, and if they have a positive award that's enforceable, and the correct party is named, they can follow the procedure and enforce, as any other contracting party could. We also have the other questions, which are, we are Russian-based entities, we have positive judgments. Can we do anything in the UAE? And obviously the answer is, of course, yes, following the same procedure, the same mechanism, and the same status quo. The only obviously conditional part of it is the banks. And I think, again, the previous panel discussed that. We see positive trends in the UAE. Mr. Ali mentioned the Russian bank that has been opened last year, I believe, and is operational and running. And we think that's a very positive step forward. And we'd like to see more of that. Because again, and the last point I would make is the UAE has always been welcoming of commerce and business, despite an regardless of political ideologies and political disputes. And I, for one, and I'm sure many will agree, think that that should be championed and that should be welcomed and that should be showcased, and not, we shouldn't be shy and or quiet about that model, this particular model, which I think will work.
If these sanctions cannot or sometimes can, of course, affect the positive awards, they can also affect the negative awards,
Yes.
I suppose. And I think that maybe agree that the best way how the jurisdiction can, act. So if you win, you receive your money. If you lose, you lose your money, and that's a fair point, I suppose. Thank you. Mark, do you have anything to add? Because as far as I understand, we have like 1 minute and we shall end our session.
So I'll do my Rolls Royce point in the 1 minute. Okay. Just very quickly, the New York Convention provides that a national court can refuse to enforce an award on public policy grounds. Touching on the theme of the ADGM adopting English common law in its approach. There is an English case, the name Iran Ministry of Defense v. International Military Services Limited, which could, if the ADGM court wanted to fully exercise the English common law approach, give an indication that the ADGM court may be sympathetic to a public policy refusal to enforce an award. And you've got a paucity of local sanctions here, but if, as has been held in other cases, EU and UN sanctions are treated as international public policy, there may be an issue there in the ADGM courts. Hasn't been tested, but I can see a kernel of an argument there, which people should just be aware of when they're making the decisions as to how they want to proceed.
I've got 2 questions, but maybe one. Concerning onshore enforcement. Onshore enforcement of a UAE award. First, do I still need, when I go to the court for enforcement, to produce an original of the arbitration agreement or a certified copy of the arbitration agreement? And if that's the case, and if I'm an arbitrator, and I know from the outset of the arbitration that my duty is to produce an enforceable award, should I be asking the parties at the outset of the arbitration to confirm that they have an original or a certified copy of the arbitration agreement? Or will I ignore it because I want to continue to sit as arbitrator? And as Anna said, after we've issued the awards, we generally forget all about the matter.
It's a very good question. Thank you. Generally, we would prefer and we advise the former, which is check if the original is there at the beginning of proceedings to be able to be comfortable with a enforceable award at the end of the proceedings. That's something that we have always advised as counsel, and even as arbitrators sitting ourselves. The first thing, or one of the first things that we do is check if they, and ask the parties to show us the original contract. We have seen some tribunals that don't do that and then get frustrated at the end of the proceedings. But some of them are fine because they've received their fees, of course. So it depends which way you want things to go and which way you look at it. But legally speaking, black letter of the law, we would always push people involved in the process to request the original. And yes, enforcement does require the original and certified Arabic translation.
So you really need to make sure you keep those originals safe.
Absolutely.
For as long as it's possible, you may have a dispute.
Yes, absolutely. Yeah.
Thanks for the speakers. Actually, it was very interesting. I have no questions, but it's a comment on. They want to ask a question, tricky question.
Yes, please don't ask me a question.
Yeah, we are online, and everybody's here, so later on we'll discuss. But talking about the arbitration law, yes, there was a lot of positive things, and We adopt a lots of electronic means. So now that is something which is important. It was impossible before. It's make it easy now for most of the arbitrators living abroad to conduct it online. Signatures, not all of them it's on the same time. All time, as Anna said, everybody should come. Though it's good for a tourist, so people
Yes.
come more here. But yeah, so but no, now electronically it's since it has been accepted, so that is there. Signature on different dates, that is acceptable. Even if there is an issues now on the signature, the judge can or the party can request the judge to stall the process. They send it back to the tribunals, please correct it, which is also make a sense, because you can't lose the whole work of the arbitrators because of small issues. Signatures on all pages, I agree, is still there, but the principle was behind it that you can't make a difference between the signature of the tribunals on the blank page than the all reasoning on others. There is some sense also behind it. So now that, yeah, it is, you know what, I always said to the tribunals, I said, what is the problem? Just more spaces, then it will go to the same page, then it's okay, you can sign it that last pages. So it is something, but again, curable, you can cure it. So that is something which is positive on our law. Talking about the courts, there is one judgment, I don't know, maybe Mark, he can also, I'm not sure whether this is a recent judgment. It was interesting. It was an arbitration award, ICC arbitration award, Abu Dhabi in ADGM. And that case, I was the sole arbitrator. So I follow, because I have a way to follow my award, whether it has been nullified or not. Okay, so interestingly, Abu Dhabi courts, and when the party went for ratified, Abu Dhabi High Courts, they said, we have no jurisdiction to ratify it. It is an ICC ADGM branch. The seat, it will be then the jurisdiction for ADGM to ratify it. And that was the first of kind, which is good move to see it, how that will help. And that is, I think, is in you. I'll leave it that for you to comment. But going to the last point, which I want just to talk about it, is about the sanction. I'm a believer of that the sanction should not prevent people to pursue their rights. Whatsoever is the right is the right. We are a legal, we are not a politician. We should not be involved on the politics. If unless it's a terrorist list, UN list, then it's okay, because there is a majority of the world they accept it. But you prevent an individuals or a corporate to pursue their rights. That's supposed to keep. Suppose there will be a different space between a political decision and the legal decision, because end of the day, the right is the right. You need to be fair with your enemies always. This is what we learn it. We need to be allowing everybody to exercise their, we can say, birthright. This is their right. You need to pursue your rights. So I think, and I really like our country when they said we are neutral, should not be engaged on any other political issues, and we have to keep for sustaining the business for the world. It's supposed to be very neutral. The business is the business. We should not mix between the politics and the business. This is what I believe, and that's why I think so. Even the government here with Iranian, we have many direct conflicts, but I think there is a lots of business here. Mark, he's here from years. Dr. Osama, Areen, everybody is here from years. They know that there is a good business people still here. Now, if they breach the law, if they go on terrorist list or on the breaching the UN decision, yes, because we are a part of UN, we have to follow that, right? But did we stop them to do the business? No, that's there. So this is what I always believe. And the country, I think so, he's trying, despite there is a lots of pressure, of course, that's normal in the politic. But I think so, the way it's adopted, and it is, as I said in the first session, there is a lot of positive things to keep the UAE neutral. And I think that's will hopefully that will continue. And inshallah, that we make always UAE is a place for everybody to do a business, welcoming everybody, regardless from where they are coming. Thanks a lot for that. And thank you. Really very good session for the panelists. Thanks a lot.
Thanks a lot to all the panelists. So, ready?
Maybe I took the floor from everybody.